Move to adjourn? And the public hearing will be closed, and we'll move on to the Plan Commission meeting, joint with the town board. And we'll call that to order. All the Plan Commission members are present. And so that everybody understands, the Plan Commission members are to my left and consist of Al White, Chief Buckholz, Bob Flanagan, and Bob Stigler, myself, and Brian Fisher. And we make an advisory recommendation to the full town board, which will take the matter up during the town board meeting. And the reason I'm pointing it out, I just want to make sure that everybody understands that there's no confusion, that this is an advisory to the town board. We'll open up with citizens' comments. Anybody? Going once? Going twice? And we'll move on. Number 3, discussion with the town board and plan commission, possible action by the plan commission on the rezoning for Sunset Prairie LLC. The applicant again is Steve Circus. We'll open it up. Mr. Flanagan.
Well, I voted against it last time, and I'll vote against it this time. I agree with the chair of people out there that we're going to have, it's going to exacerbate an already difficult situation. And I agree with the neighbors. However, it is a commercial area. To put anything other than commercial in there is great, but I mean this driveway business, I just don't see where that's going to help.
Yeah.
Information came, actually I think it's part of the planner's report, that part of the driveway location was based on potential development to the east of this site as well. I wasn't there for those discussions. I don't know what took place. Mike, you were chairman at the time, and there was a committee in place. Can you recollect any of the discussions, how these things came about?
It was 15 years ago over there.
Sorry, buddy. I do have to agree, if you take that section of land to the east, which does go all the way to the railroad tracks, both to the east and to the north, that site is actually big enough that a corporation such as Lowe's would put a store in there. And if you put that kind of a marketplace in there, that kind of traffic, I can understand why planning at that time said we're going to restrict the access off of Prairie Avenue east to Sunset. That's the case. I have to agree with Mr. Flanagan. I don't think it's a good idea. If we're really doing good planning, we need to look at that area to the east as well and take that into consideration.
If that was a Lowe's stand, wouldn't they take out every home in the area there?
Right.
Mr. Chairman?
Yes.
I have a couple of comments. One is a bit general in nature, and then a specific comment or two. The general comment, just kind of as a reminder to people in the audience and the people at the board table here regarding the town of Waukesha's jurisdictional authority in this matter. Attorney De La Mora has reminded us from time to time appropriately the town has what is called village powers enacted back in 1943. Doubt anybody in the room remembers that, but it's a provision that is in state statutes, and simplistically, and Hector, you or Roger could correct me on this, but make it real simple. It basically gives a town who adopts those village powers some jurisdictional authority over land use and zoning within the town. And the point that I want to make, and I appreciate many comments have been made about the appropriateness of the location of Cafe Bistro, Dunkin Donuts, that type of thing. The town plan commission, the town board here, does not have any jurisdictional authority over things that involve land ownership and all of those things associated with it. Our role and responsibility and jurisdictional authority is limited to land use. So when we wander a bit, and I'll confess that I am a wanderer with a considerable skill set, but when we get into talking, as we have even on other matters about public and private use and profitability and appropriate location and placement and so forth, the town has no jurisdictional authority in that area. And basically, we are not central planners. It's capitalism at work. So when it gets to people competing one against another and so forth, any of that discussion really doesn't have any place here. So I want to remind people that that's a general comment. We are dealing with land use, not any issues related to land ownership. Specifically to the point, and this will be a bit shorter, in order for me to be able to support removal of the restrictions, namely the prohibition against restaurants with drive-through lanes and the prohibition against additional access to Prairie Avenue, I need to be persuaded, me personally, that some circumstances have changed since those restrictions have been put in place. I'm willing to be open-minded on it, but I've not yet seen anyone make a compelling argument to me that circumstances have changed. And for that reason, I'm inclined to vote against the request for the change. A bit of follow-up or sidebar to that, which may be irrelevant or moot given what I just said about the fact that I'm not persuaded anything's changed. I am troubled because I think, and I would ask Hector or Roger to correct me if I'm mistaken, but I think the proposal that has been laid before us is to remove those restrictions as they pertain to the 1.08 acre parcel, roughly acre parcel of land that is the subject of discussion. That's a bit more detailed, but that troubles me because these restrictions and prohibitions were put in for the entirety of that larger tract of property, which, I don't have all the information to look at it, but I think at one point before that was redivided and everything constituted some 12 acres. So even if I could get over the threshold of being convinced that something has changed, which would persuade me to support removal of the restrictions, I'm still troubled because I think the specific thing that's been put before us applies but only to that 1 acre roughly of property that makes no sense to me. If I've misread that, I'd invite Roger or Hector to set me straight.
At the risk of blocking a fine line of what Brian said, I agree with everything, the part about the 12 acres and then taking in the whole thing, and there's a bigger plan out here that was put in place back in 2004. And I agree that we need to keep the integrity of the town intact when we create an ordinance, and then we're gonna change it just for one situation here that somebody doesn't like. We have businesses, and this is where I'm walking the fine line, Brian, you said about it's capitalism at its finest, and I have no problem with Dunkin Donuts going in there. That, as long as we're on the same playing field with everybody else in that complex. And we created, back in 2004, this ordinance that restricted drive-up windows or whatever. And I think in order to be on a fair playing field with everybody in that complex, we need to keep the integrity of that ordinance in place. And again, I can't support this either. I really believe that we need to keep that integrity of the town intact here and stick by the old ordinance.
I'm going to offer a fresh view since I haven't lived in town for 30 years. In 2009, the Town of Waukesha Plan Commission members that are sitting here, except yourself, Bob, provided a smart growth plan that covered a 30-year process, 30-year outlook. And they said that the corner of Sunset and St. Paul should be residential. Yet, just in the past 6 months, we've converted 5 residential homes, which was against the city's recommendation. The city wouldn't do it, but we did it. We agreed to put in a Walgreens and an Aldi in a residential neighborhood. The same body also approved or left a residential area, which is one of the constituents that pointed out is now a baseball complex. We just rezoned it to a park because it made sense. I voted in favor of it because it is a park. Mark Belling this week talked about this very issue and said that communities like ours that are in flux and change, going from a very rural community where the city has been imposing its borders on us, imposing its way of life on us, changing lot size, changing residential to commercial, that communities like ours find ourselves divided when that development knocks on our door. In this case, we're not talking about should we have commercial here, should it be residential, should we have a baseball field that operates for a long period of time, or should we have residential, housing there. We're talking about should a property owner, land rights, should a property owner in an area that has dramatically changed. There are drive-thrus up and down Sunset. You can't go a block and a half without running into them. We have the new shops at Fox River, which are exploding. This is not residential area. These were the same discussion points that happened with Sunset when it was Walgreens and Aldi. This area has changed. This is a commercial strip. A drive-through there is not going to impact, in my opinion, the traffic flow or the patterns of any sizable amount, any given amount of time. Certainly nowhere near the impact that the shops of Fox River and all the drive-thrus that have popped up along the way. So what happened in '04, we can say what happened in '09. Town board saw its way to say, hey, yeah, that was '09, things have changed. I think here as well, we're seeing not only do we think that things have changed, but the county is in agreement that things have changed. This is no longer a mega overview of a big time project. This is a small outlot, and I think that if we read Roger's work here, he points out that we've already approved this plan, knowing that there was a potential conflict with language that the county had, and we made the developer go back away because originally his driveway access was further on Prairie. And we said in February, go back and provide a solution for that because we don't think that'll work. So they went away, they came back, and they said, hey, now we've got this roadway, we got the approval, we can move it further down, further to the south, and create a less congestion and provide a little area. They worked with us when we said, what about the drive-through lane? Can we design it differently? Somebody recommended some kind of a pork chop. None of this language was language of, we can't have this thing in town. This was all language that said, this makes sense to be in the town, to fit in this development. We just need to massage it a little bit. And they've come back several times and provided that. And obviously by my tone, I intend to support that.
Can I respond?
Absolutely.
Joe, you're right. Nobody's saying that this shouldn't be a business. But with any kind of zoning, the mechanics of that zoning have to be configured to what's there. And it makes no sense to have all of this traffic that's already on Prairie Avenue, which is really a side street at that point, north of Sunset Drive. It makes no sense to have all of this traffic there and exacerbated by the stop and go lane. If we had a few more 100 feet in either direction, this would be a no-brainer, but it isn't the case. So, you're right, this is gonna be a commercial area. And that I think some point in time, in maybe our lifetimes, you're gonna see most of Sunset Drive on both sides of the street be commercial areas. And you mentioned about tearing down an area that, yeah, the value of the property will be a lot more if it's all commercial. We all agree on that. Now, that means people selling their homestead, but the point is, just looking at dollars and cents, that's what it's gonna be. It's gonna be a commercial neighborhood. There's no avoiding that. That still doesn't allow people to create something within this commercial neighborhood that's mechanically not gonna work. And that's my issue.
And I respect that your vote was the only one back in March in opposition to this development. And I respect your point of view.
Yeah.
I believe back in when Sunset 59 Walgreens, back there, Joe, I think I voted no against that development. Back then, I think I was the only one that voted no on that, which was 30 years ago. I supported the neighbors and everybody that lived in that area back in there. Anyway, back to this, we're still gonna keep the business district there. I think when they impose the restrictions on that property, I have a hard time removing them also. I echo quite a few of these members up here tonight on that, to change the language on that. I haven't heard anything, reason why specifically why we should change the restrictions. That would vote me, persuade me a different direction. So I'm gonna be opposed of this.
So how do you reconcile that with Jason Fruth's comments that says, the department staff believes the proposal to remove County Park and Planning Commission from the site plan review activities relative to this property is appropriate? I mean, this is the manager of planning and zoning at the county, and Roger, I think you could probably add some color to the conversations you've had with him. I mean, the county pretty much wants out of this oversight because they feel that it is, to use the reverse of his word, inappropriate for them to have the oversight. Am I stepping out of lines?
No, that's absolutely correct. Just a little bit of history here. Understand that what we all accept as common practice today, being conditional uses, affords the town and even the county a little bit better control. What they used to do was conditional rezone, which is what this is a result of. Originally, this plan in '04, there was a plan with a drive-through that the town approved and sent to the county for confirmation, and at that level, they imposed a restriction for the drive-through. That did not originate here at the town. The county imposed that because of a number of factors. And they did that through this conditional rezone, which creates a whole daisy chain of enrolled ordinances. That's why this has been so confusing. But there are, it's documented that the town has, in a number of instances, considered and approved the drive-throughs on this location. You know, the county, I think, just wants to be out of it. They would prefer that we handle it within our own jurisdiction. And they are, in many cases, this is not an isolated incident. They are, in many cases, revising many of their conditional rezones and redoing them as conditional uses.
I want to make sure that letter from Jason Fruth is not misconstrued. He's not saying that we should remove the restrictions. He's saying remove the county from being involved in them. That's all he's saying. He nowhere says remove the restrictions. He's just saying remove us, deal with it yourself.
I don't think I misconstrued or misrepresented what he said. That's why I also gave everybody a copy of it. I believe I read his letter out loud, and I believe I just read the sentence out loud, and that's exactly what he said. It is appropriate that they be removed from oversight. I mean, they don't want the oversight. They're the ones that have this in place. If it's their ordinance and they don't want it in place, and we had a 6-1 vote on the plan commission to approve the plan with the drive-through. I don't know that there'd be another business that would come back and want to do business with us if we approve a site plan and say, sure, you can go ahead and build that, go to the county and get your approval, which is a standard process. We didn't even need to list that item on the approval. Anything we approve here, they have to go to the county and revisit it, just like when Price Plumbing went. We approved something, they went to the county and tried to get their site plan approved, and they were told to do some other things, and they went back and did it. The same thing would have happened here, and we approved their site plan with a drive-through.
Joe, you just said again, you said the county doesn't want it in place. That's not what
Do
the
you-
county's
do you
saying.
want me
The
to
county is
repeat?
saying, what they're saying is they want to be removed from the process. They didn't say that they don't want the process, that they don't want those ordinances in place. They said they want to be removed from the process.
Yes.
And you said that they don't want the ordinance in place, and that's not accurate.
I'll leave it. We can work on it.
Mr. Chairman, I have a question. When does the developer get involved here? These restrictions have been there since 2004. If I was going to try and build a building there, I would want to know all of the restrictions contiguous to the use of what I'm going to do. And if I know that, why is this coming up now? Why wasn't this an issue before that this was actually a restriction within our ordinance for that site? Is what I'm getting.
It's a great question.
It seems to me that due diligence was not here. So now we're trying to correct something that the guy that's going to want to build this building, or the guy that wants to sell it, should have made somebody aware of the fact that this is a bridge that's going to have to be crossed.
I could just say that.
Use the mic, Steve.
Sure. So Dunkin Donuts asked to run their own approval process due diligence, so we just took a back seat. What I understood from their civil engineers in reading their ordinance, which is written in a pretty convoluted way, I'm sure if any of you have tried to read all of these conditions that have been attached, it's not very easy to follow what they're trying to say. He interpreted some of that language as saying that those restrictions were only applicable in the early stages of development. Because there's a clause in there, something you might remember this, Roger, there's a clause in there that says something about until further developed, and their belief was that it didn't apply, and that's why they went ahead. I think that may be the case, but I'm not an attorney, so I can't opine. I thought it was a potentially valid interpretation.
My issue is, some party that's part of this should have known all of that before all of this deal was starting to go together. And
Well, as I
it should
say,
have brought together.
they read it, and they were aware of it, and they interpreted it to say that it was no longer applicable because this was no longer new land, greenfield site to be developed. It was a site that had already
Okay.
achieved.
If I could just interrupt you, you're selling the property, correct?
Correct.
Wouldn't it have been incumbent upon you to say, look, this is also an issue here within this particular location?
You know, I wasn't personally involved in the
I
original
didn't say you
development some
personally,
years
but
ago.
your company
No, I'm
would.
just saying, but I was involved in this transaction. Dunkin Donuts said they preferred to run the process themselves, so they felt comfortable doing their own due diligence, looking at the ordinances and looking for approval.
I understand.
Now, I guess I'm a little confused because as I say, the plan commission and the town board approved the site plan and the plan of operations after hearing testimony from the public, from engineers, from Dunkin Donuts. All of those factors were considered. And now you're raising questions about traffic and where the driveway should go. You ask if conditions have changed. Yes, there's, for a 40,000 square foot grocery store, you're gonna need about 200 parking spaces to give you an idea of how much traffic that's gonna generate. They're gone, St. Vincent de Paul is a much lower volume business, and you're gonna have a 4,000 foot strip center that's gonna need about 20 parking spaces. So yes, there is much less stress on that intersection than there were before. That's why it is different. And I think apparently the county, for whatever reason, imposed this language that Roger found this out historically. I wasn't sure where that came from, but the county imposed this language. Apparently, when you reviewed the site plan and approved it, you didn't think that a restriction on drive-through was appropriate because you thought that it was a good design, it was well-planned, it was well thought out, well-engineered. And you said, fine, let's do it, it's approved, let's just make sure we're not violating any existing language. So all we're doing is cleaning up that superfluous language that doesn't apply. And in my view, it does apply to the entire northwest quadrant, not just the outlook. And Cafe Bistro or anybody else is certainly welcome to bring a site plan before you for a review if they want to, look for a drive-through. If it would help their business that much, I think they should do that. I don't think there's any inherent reason why they shouldn't be allowed to have a drive-through. But of course, that should go through the normal channels of the review process with staff and with the commission and the board. So anyway, I guess I'm troubled by the fact that all these issues that were previously considered being revisited this evening. I think it's a simple matter of saying, you asked us to just verify that we're not in conflict with existing ordinances. We researched it. We verified that there were potentially some language issues that were in conflict. The town's attorney drafted an amendment which cleaned those up. We're restoring essentially back to the original underlying zoning. And I believe we should go ahead and issue the final approval. Thank you.
Mr. Chairman, can I just offer a bit of a comment or two in response? First of all, I read the ordinance, and the first time I read it, I didn't find it convoluted at all. That's number one. Number two, I'm a little bit concerned about the discussion about St. Vincent de Paul as a traffic generator. Mr. James spoke before. We are delighted to have them in the town and occupying that property, so that's not the issue. If we want to talk about things changing, what is to say, and I hope they are there for many, many years to come with a successful operation. We love having them there, but that could revert to some other use at some time in the future that would generate a heck of a lot more traffic. If I were to use your analogy, and I'm not sure how familiar you are with the rest of Sunset Drive, but go down to East Avenue, the northeast corner. There's a Kmart there with a sea of asphalt that won't quit. If I were to use your argument, I'm going to go one step further. There's a huge development in the property which is now in the city east of there, up near Tenney Avenue, between there and Racine. If I were to use your argument in this instance with low traffic volumes from St. Vincent de Paul, then I could apply that argument over on Sunset in the area of East Avenue, and I could say, boy, look at these traffic counts are way down. I mean, that is a huge vacant property to be redeveloped. Another thing, traffic volumes are going to skyrocket in that area. Go look at it. It's a ghost land now. It's not going to be that way forever.
Mr. Chairman,
Yes.
I make a motion that we disapprove this.
Second?
Okay.
Is there any further discussion?
Well, the only thing I would ask for is a clarification of the motion for disapproval. A vote of yes would be to disapprove then of the request, correct?
And specifically the request of changing the ordinance
For
before you.
changing the ordinance in place.
Chairman Merrick?
Let's read that.
The motion is to deny the rezone. So voting yes would mean that you want to deny it.
Yes.
Commissioner Buchholz?
Yes.
Commissioner White?
Yes.
Commissioner Flanagan?
Yes.
Commissioner Stigler? Supervisor Fisher?
Yes. Motion carries. We're gonna move on to